Before we even step into this courtroom, you need to understand what makes this case so intense. On the surface, it looks simple. A landlord wants their property back, and a tenant is being asked to leave. But beneath that surface, this case is packed with miscommunication, legal technicalities, and a single mistake that could completely flip the outcome. We're looking at a tenant who claims he's done everything right over a decade of on-time rent payments. No issues, no problems. And now suddenly, he's being forced out while he's in the middle of building his own home. That's a tough situation. But on the other side, the landlord says they've asked multiple times, followed the legal process, and now simply want their property back for personal use. So here's the real question. Is this a case of unfair eviction, or just the law being applied exactly as written? Because in landlord-tenant law, there's one brutal truth: intentions don't matter, paperwork does. And as you're about to see, one small legal detail, something most people wouldn't even think twice about, might completely derail this entire case. Watch closely, because this is where things get interesting.
All right, so this is a landlord-tenant action. It's just a termination of tenancy. You can understand me, right?
Yeah, that's why I'm trying to make a request. If I have my son can speak on behalf of me.
I can't let him do that. He's not a lawyer. Why can't you tell me?
Okay, I am living in this place for since 2012, and I have paid my rents on time all the time, and a couple of times in the whole entire time over 12 years, we only signed 2 times the lease. And at the last lease, they were asking to vacate the place, but I requested them that I am building my home. Please allow me to stay here until the June. So they said, no, you have to evacuate the place. I never been late for my
I know, but Mr. Baydoun, do you want to respond to that?
Yes, Your Honor. As indicated, we submitted a notice to quit for recovery of possession. This notice to quit was actually sent out in January, but it was, I believe, the 3rd time it was requested to the tenant to vacate the property. The first time being verbally through the property manager. The second time, which was mailed out, which he refused service for. And then the 3rd time, we were finally able to get him served. You know, the landlord has requested this property back all 3 of these times for personal needs. It's requested him because he needs the property back. He's in no way, shape, or form trying to, you know, do anything nefarious towards the landlord, but pursuant to the agreement, he needs the property back for personal reasons. He has a daughter that he would like to put in the property, and it's his property, and he has the right to it, Your Honor.
Let's pause right here, because this is where the legal framework becomes critical. What the judge is explaining without saying it outright is that once a lease expires and no new lease is signed, the tenancy automatically becomes month to month. That means the landlord doesn't need a long-term reason anymore. They just need to follow proper notice procedures. And based on what we're hearing, the landlord's side is claiming they gave notice multiple times verbally, by mail, and finally through legal service. From a legal standpoint, that's strong positioning. But here's where things start to feel uncomfortable. The tenant isn't denying the situation, he's asking for time. He's not refusing to leave. He's saying, just give me until June. So now the case shifts from legal rights to human reality. And this is where courts get tough, because judges don't rule based on sympathy, they rule based on law. But still, ask yourself this. If someone paid rent for 12 years without issue, do they deserve more flexibility? Or is the landlord fully justified in taking back what's legally theirs?
Mr. Shahzad, there's not much I can do for you. I can't just make my own rules up here. And they're entitled to the property back by all means that I can tell. It became a month-to-month tenancy when the lease expired at the end of April of 25. And there's not anything I can do. I can't say you. What do you have to say?
I have not received any notice for month to month. All of us asking to just leave. And I requested the property manager, and he was kept on saying back and forth, let me talk to the owner, let me talk to the owner. He was not clear that you have to leave now. He was kept on saying to me, and all of a sudden, I got the letter from the lawyer. When I called him back, he said, well, I didn't know that they're gonna hire the lawyer.
What asking me to do, sir? I can't let you stay in there until June. I can't let that happen. These are not my rules. I don't make my own rules. I don't write statutes. I don't write court rules. I mean, I know what they are and I'd follow them. I can't do that for you. I'm sorry. I really am.
Can I stay until May?
You're asking for a lot. They're entitled to the property by April the 9th.
Sir,
They did, sir, I can't do that. I just can't do that. I'm sorry. But what day did you send out your notice to quit? Your notice to quit was sent out January 21. So you've known that you have to be out now for over 2 months. They told you you had to move out by February 20th. You can talk, sir. You don't have to raise your hand.
I spoke with the property manager. He was saying, let me talk to the landlord. Then he will get back to me. That's how the time got lapsed. If he had told me he have to leave it now, since he was talking to back and forth to the owner because he lives abroad, that's how it took the time. And then they saw that if they cannot get in touch with the landlord, that's how they just make it sure to make me evict this.
I can't do anything for you. You're asking me to disregard laws, and I will not do that. I cannot do anything for you. You have no proof of this. They filed January, what did I tell you? January 12th, the notice to quit. January 21, it said you had to be out by February 20. This is March 30. I can't just extend out of the goodness of my heart. I don't owe this. I can't do that. This is not my money. This is not my property.
This right here is one of the most difficult moments you'll see in cases like this. The tenant says, I have nowhere to go, and the judge can't help him, not because he doesn't care, but because legally he's not allowed to. This is something a lot of people misunderstand about the court system. Judges aren't there to fix situations. They're there to apply the law. And sometimes that leads to outcomes that feel incredibly harsh. But now something subtle is happening. The judge starts asking about rent payments after the notice to quit. And if you know anything about eviction law, this is a huge deal, because if a landlord accepts rent after terminating tenancy, they may have just undone their own case. So suddenly, everything shifts. The tenant who looked like he was losing might actually have a way out. Stay locked in, because this is where cases turn.
I have nowhere to go, sir.
I don't know what to tell you. Mr. Beydoun, do you care to expound upon what you've already said?
I guess the only thing that I would add, Your Honor, is although the notice to quit that was finally served on January 21st, the tenant was made aware of our request since October of 2025. Other than that, I can't really speak to anything else, Your Honor. The landlord has made it very clear that he does need the property back, and he's given him more than enough time to vacate
Has
the
he
property.
been accepting rent?
He stopped accepting rent in as of February of 2026. He did not accept rent for March.
Go ahead.
I paid the rent for the March as well.
That payment was denied, Your Honor.
When did you pay the rent for March?
On the 27th, because from the
Slow down. March 27th, you paid the March rent, or February 27th, you paid the March rent?
I paid the February already, then I paid the March rent because from the landlord, it was denied. Then I sent to the property manager.
Well, they accepted rent after they sent out the notice to quit, though.
We stopped
Right?
accepting. We stopped accepting rent in February, Your Honor. We have not accepted.
Day was the February rent paid?
I could double check, Your Honor, but I believe that there was nothing accepted since
Your
February.
Honor, may I add a detail?
No, sir, I cannot let you speak. I'm sorry.
I
I'm
understand.
sorry. I really am.
I have a proof of paid the rent for March.
Wait 1 second. Let me sort this out, okay?
Thank you, sir.
How did you pay the March rent?
Through Zelle.
I'm sorry?
Through Zelle?
Zelle, right, I get it. Did your client accept that payment? Did your client accept the payment in February?
I
Yes.
see, Your Honor, if I may, I could say for certain that payment was not accepted as of March.
Well, did they accept one for February?
I am not certain, but I do see that there was a payment for February, Your Honor, as of, it was paid on February 9th, 2026, not March.
Why shouldn't I dismiss the case then? They can't accept a payment after, they cannot accept a payment after they've terminated tenancy with a notice to quit. Why should I not dismiss the case?
This is
Yeah.
it. This is the moment that changes everything. The judge asks a very specific question. Why shouldn't I dismiss the case? And that's not a casual question, that's a warning. Because in eviction law, accepting rent after issuing a notice to quit can legally reset the tenancy, meaning the landlord has to start the entire process over again. And now the landlord's attorney is hesitating. That hesitating? That's everything. Because it tells you one thing, there might have been a mistake. And in court, especially in cases like this, one procedural mistake can outweigh months of preparation. So now the power dynamic flips. The tenant, who is moments away from being forced out, might now stay longer simply because of a technicality. Let me ask you this. Who's really in control here, the law, or the details within it?
Your Honor, if you just give me 1 second to reference my notes, I apologize.
Problem.
Okay.
Your client made a mistake by accepting that rent, right?
Your Honor, if
Tough
you
to
could just
be a
give me
lawyer sometimes, isn't it, Mr. Bigdoon? Tough to be a
Yes,
lawyer.
yes, I'm just trying, if you would just give me a second to confirm if the
I'll give
payment,
you
Your
all the
Honor.
time you need. I can go
Thank-
on to another case. I'm not here to
I-
rush.
I
I'll
appreciate, Your
pass
Honor.
the,
I don't
I'll
want to make,
pass the case. You guys stay right where you are.
I don't want to make any misstatements on the record. If you just give me 1
No,
second.
I
Your Honor,
gotta take your
apologize.
time. You guys stay right there. Just mute yourselves,
Thank you.
Mr. Shazad. And then when I call your case again, you unmute, okay? Mr. Baidoon, your name again.
Mohammed Baidoon appearing on behalf of William Berg,
So you
LLC.
conferred with your office and they concluded I'm right, right?
You are right. You are correct, Your Honor. The
Okay.
payment was accepted for February.
So I'm gonna go ahead and dismiss the case. There's nothing short of me doing. You're gonna have to start the process over.
We understand, Your Honor. I did request, I understand, you know, if there's any way we could just extend this by 30 days, or does the case have to be dismissed and refiled?
I think it has to be refiled. If you guys want to do something, if you guys want to go into listen, Mr. Shazad, I want you to listen very carefully. And if you don't understand something I'm saying, I invite you to interrupt me, okay? They did something they shouldn't have done. You can't send out a 30-day notice to quit, 30-day notice to quit and terminate tenancy and then accept payments. So I am going to dismiss this case.
Thank you,
Now,
Your Honor.
that means they've got to start the process over. The other alternative, if you guys still want to do this, I'm not going to get in your way. If you wanted to go into a breakout room and agree that you have to vacate on or before June 1st or May 20th, or I could care less when you come up with, I'll be glad to do that. So what is your preference, Mr. Shazad?
I was willing to talk to them in the beginning, but they made me go to the court. But I am intending to leave this place the 30th of June. That's second option. Whatever.
Wait a minute. I just want to know, sir. Listen, I don't need to know any of this.
Yeah, I will leave June 30th.
You
Your Honor,
guys,
I know it's his request, but I do think it'd be in his best interest that we do go in a breakout room.
why don't you guys go in the breakout room and you can see if you can resolve it.
Thank you, Your
I'm
Honor.
only telling you, I'm either going to dismiss this case and make them refile, in which case they have to start the process over. Or if you guys choose to go into a breakout room and agree on a vacation, a date that you have to vacate by, that's acceptable to both of you, that's fine too. Do you understand what I'm saying to you, Mr. Shazad? I want to make
Yes.
sure that I'm doing a decent job of conveying.
I appreciate that, and I would like to talk to the lawyer. If he doesn't, then I will request that you can dismiss the case for me.
You guys go talk in a breakout room and then you come out and you both let me know what you want to do, okay?
Thank you, Your Honor.
Thank you. Thanks,
Thank you, Your
Mr. Baydoun.
Thank you, Your Honor.
All right. Did you two talk and resolve this, Mr. Baydoun?
We unfortunately were not able to resolve, it was requested that the case be dismissed by Mr. Salim. I would, if I may, Your Honor, just ask Mr. Salim to stop attempting to make payments to my client, as my client will no longer be accepting payments.
Yeah, I'm gonna go ahead and dismiss this on my motion, and they'll have to start the process over. I'm sorry, you just can't do that. Thank you very much, but
Understood.
don't tender any more payments to them, Mr. Shazad. They're not going to accept them, okay?
Thank you, Your Honor.
Good
Thank you.
luck. What's that?
Thank you.
And just like that, the entire case collapses. Not because the landlord didn't have a valid reason. Not because the tenant proved he was right, but because of one critical legal mistake accepting rent after terminating the tenancy. That single action forced the judge to dismiss the case entirely. Now the landlord has to start over from scratch, new notice, new timeline, new process. And for the tenant, that mistake just bought him time, something he was desperately asking for from the very beginning. This case is the perfect example of how legal systems don't operate on emotion, they operate on precision. Every step matters. Every action counts. And sometimes, the smallest oversight can completely change the outcome. So now I want to hear from you. Do you think the tenant deserved more time from the start? Or did the landlord do everything right except for one costly mistake? Drop your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.